Swayam Prabha. Digital India. Educated India.
Hello friends, welcome to the class of Maritime Law. I am Dr. Ashutosh Acharya, Senior Assistant Professor from Law Center 2, Faculty of Law, University of Delhi. In continuation to our previous classes, we will today discuss about shipping laws and regulations in India. So far, we have touched upon law of the sea, international, and to an extent national as well. We have in detail discussed about admiralty laws, which talks about claims and jurisdictions and specifies what all claims can be brought before the admiralty jurisdiction of the high courts in India. And there we see that with respect to the unseaworthiness of the ships as well, claims of passengers against the ship and similar other claims could be brought before the admiralty jurisdiction of the high court. At the same time, we see that in the previous two modules we had discussed about navigation and safety, wherein we had specifically discussed about the international standards incorporated in India and existing individually as far as rules pertaining to navigation is concerned. What are the measures that are to be undertaken for a particular ship to become a seaworthy ship? We discussed in detail obtaining of certificate by the ship, and not only by the ship, but also obtaining a certificate by the competent individuals placed on the ship, that is the manning of the ship, the personnels that are to be placed on the ship, which may include engineers, which may include the master, first mate, second mate, or navigational watchkeepers, etc. The equipments that are to be placed to be in good condition, workable condition, to be as per the latest standards. So, all of these things we had discussed in the last two lectures. We also discussed that how central government undertakes to allow ships to sail, and in case of violation, what all kinds of acts can be considered to be offences as far as navigation of a ship through Indian ports are concerned. We also talked about nationality and registration of ship. What is the requirement of a ship to get registered at Indian ports, and what happens when they are not in port and the registration has expired. So, different scenarios have been discussed in the last classes. Continuing our discussion from the same part, we will now see how in India a distinct law has been made, or distinct provisions have been incorporated in the law apart from the provisions that we have already discussed. The provisions that we discussed were largely from Merchant Shipping Act. Yes, prior to that we did take into account Admiralty Act, but under Merchant Shipping Act we had discussed about nationality, registration and other aspects as far as seafaring ships are concerned or seafarers are concerned. What is the policy making body, how they touch upon the policy aspects as far as seaworthiness is concerned or as far as welfare of the seafarers or seamen are concerned. Now, today in this class we will talk about the shipping laws in general and to certain aspect specific as well. With respect to pilgrimages, we will talk about the ships that are considered to be trade ships, special trade ships. We will talk about ships that are the ships which are categorized as unberthed ships. What are the rules pertaining to unberthed ships? So, we will discuss all the rules and regulations, the certificates that these ships are to obtain. What are the different kinds of certificates that they are to obtain? What are the regulations that apply on such ships? In the second part of today's lecture, we will talk about carriage of goods through sea, Act 1925, which deals with an area of transportation, the commercial aspect as far as carriage of goods is concerned, the sale of goods are concerned, through sea route is concerned. So, how the regulations pertaining to cargoes and goods come into being as far as their transportation through ships is concerned. We will discuss all of which in today's class. So, let us begin, friends, by talking about special trade passenger ships and pilgrim ships. We have already understood in general what are the requirements for a ship as far as passenger ship is concerned. But here today we will talk about goods in the second part, and in the first part we will talk about special trade passenger ships and pilgrim ships. So, the definition clause or definition provision, that is the section 3 of Merchant Shipping Act 1958, defines the different terms that we see here under special trade passenger ships and pilgrim ships. What do we understand by the word passenger? What do we understand by the word passenger ships, pilgrim or pilgrimage ships? So, the clause 24 of section 3 defines the word passenger, and it says that passenger means any person carried on board a ship except a person employed or engaged in any capacity on board the ship on the business of the ship. So, it would exclude the first mate, second mate, navigational watchkeeper, the engineers, the master, etc., and would include the person who is not any of these, who does not fall within any of these headings. So, a person carried on board a ship except a person employed or engaged in any capacity on board the ship on the business of the ship. So, it will exclude the crew of the ship. Secondly, a person on board the ship either in pursuance of the obligations laid upon the master to carry shipwrecked, distressed or other persons, or by reason of any circumstances which neither the master nor the charterer, if any, could have prevented or forestalled. A child under 1 year of age. I repeat that a person on board the ship either in pursuance of the obligations laid upon the master to carry shipwrecked. So, if there is an obligation upon the shipmaster to carry a shipwrecked is a person who is protected or saved out of a ship that is in distress or has been damaged or is about to sink in the sea water. So, a person taken from the distressed ship, shipwrecked ship, or other persons or by reason of any circumstance which neither the master nor the charterer, if any, could have prevented or forestalled. A child under 1 year of age to qualify to be passenger. Secondly, clause 25 talks about passenger ship, and it defines and says that passenger ship means a ship carrying more than 12 passengers. So, in the previous lecture we had seen that no certificate is required as far as carrying of 12 passenger is concerned. So, maximum limit is 12 passenger, but if a ship is to be certified and identified and designated as a passenger ship, it must have a certificate, and only then it can carry passengers more than 12 in number. Our clause 26 says pilgrim means a person making a pilgrimage, and in the case of passenger on board, a pilgrim ship includes every person accompanying or traveling with the person making the pilgrimage. Generally, ships when depart from Indian coast to perform Hajj in the Middle East region of Asia, then we can say that that particular ship carrying passengers will be considered to be a pilgrimage ship, and the people on board that particular ship would be qualified as pilgrim, as it says, means a person making a pilgrimage, and in case of passenger on board, a pilgrim ship includes every person accompanying or traveling with the person making the pilgrimage. Clause 27 defines pilgrimage, and it means pilgrimage to any holy place in the Hejaz or to any other place declared by the central government to be a place of pilgrimage by notification in official gazette. Further, clause 28 defines pilgrim ship, which means a special trade passenger ship which makes a voyage to or from the Hejaz, or as the case may be, to or from any other place of pilgrimage declared as such by the central government. So, central government will declare a particular ship to be a pilgrim ship, which will have a very specific particular purpose to be performed. Further, section 237, friends, we had already discussed at least up to section 235. Friends, in the previous class we had already discussed till section 235, which covers a certain aspect pertaining to seaworthiness of the ship. Now, continuing from there, as far as section 237 is concerned, it talks about ports or places where special trade passengers or pilgrims may embark or be discharged. Clause 1 of section 237 says, neither a special trade passenger ship nor a pilgrim ship shall depart or proceed from on discharge special trade passengers or pilgrims, as the case may be, at any port or place within India other than a port or place appointed in this behalf by the central government for special trade passenger ships or pilgrim ships, as the case may be. So, we see that a designated place will be identified, earmarked as far as these special trade passenger ships are concerned or pilgrim ships are concerned. Ports will be designated for it. Clause 2 says, after a ship has departed or proceeded on voyage from a port or place so appointed, a person shall not be received on board as a special trade passenger or pilgrim, as the case may be, except at some other port or place so appointed. Further, section 238 says or talks about notice to be given of a day of sailing. Clause 1 says, the master, owner or agent of a special trade passenger ship or a pilgrim ship so departing or proceeding shall give notice to an officer appointed in this behalf by the central government that the ship is to carry special trade passengers or pilgrims and of her destination and of the proposed time of sailing. So, the complete detail of the voyage is to be submitted to the to the officer appointed in this behalf by the central government. Clause 2 talks about the notice shall be given, and it says, in the case of a special trade passenger ship not less than 24 hours before that time, and in the case of a pilgrim ship at the original port of departure, if in India, if the port exists in India, then in any other case at the first port at which she touches in India, not less than 3 days, and at all other ports not less than 24 hours before that time. So, time limit has also been settled as far as this departure notice is concerned. Now, further section 239 says, power to enter on and inspect ship. After receiving the notice under section 238, that is notice of departure, the officer appointed under that section or a person authorized by him in this behalf, so, and this person appointed will be appointed by the central government, or a person is appointed by this authorized person. So, this authorized person or the officer appointed by him in this behalf shall be at liberty at all times to enter on the ship and inspect her fittings, not only inspect the complete ship peripherally, but from inside as far as its fittings are also concerned, all of its equipments are concerned, in order to check the seaworthiness of that particular ship. The ship will be inspected, as well as the fittings and equipments will also be inspected, and the provisions and stores on board. These provisions and stores might be concerned with water facility, drinking water facility, rest facility, food facility, or if I talk about mechanical aspect, the inspection pertaining to mechanical aspect can also be done, and once satisfied, a certificate can be issued. So, therefore, section 240 talks about certificates, and it says that ship not to sail without certificate A and certificate B. Clause 1 says a ship intended to carry special trade passengers between ports or places in India shall not commence a voyage from any port or place appointed under subsection 1 of section 237 unless the master holds certificates to the effect mentioned in section 241 and 242. We will come to section 241 and 242 and see the requirements. 1A of section 240 says that a ship intended to carry special trade passengers from or to a port or place in India to or from a port or place outside India shall not commence a voyage from any port or place appointed under subsection 1 of section 237 unless the master holds firstly a passenger ship safety certificate, which will be required to satisfy the requirement that all the safety equipments are in place, such as life jackets, boats, etc. An exemption certificate if the ship is exempted from the requirements of the surveyor's certificate. Then a special trade passenger ship certificate, safety certificate, or a special trade passenger ship space certificate, and a certificate referred to in section 242. The customs collector, whose duty is to grant a port clearance for the ship, shall not grant the clearance or the passage of the ship, or it will not allow the ship to start its voyage or depart from the port unless shall not grant it unless the master holds the appropriate certificate for the voyage specified in subsection 1 or as the case may be in subsection 1A. Further, we see under section 241 and 242 the contents of both the types of certificates have been mentioned. 241 talks about the contents of certificate A and 242 talks about the contents of certificate B. Let us see what do they identify. So, under section 241 it says the first of the certificates referred to in subsection 1 of section 240 hereinafter certificate A shall be in the prescribed form and contain such particulars as may be prescribed. So, there are what are the requirements of the certificate? It will be discussed under clause 2, that is, it says that in particular and without prejudice to the generality of the foregoing power, certificate A shall contain the following statements and particulars, namely. So, friends, it uses the word shall contain. So, therefore, it is mandatory requirement for any ship to obtain certificate A, and it can be given certificate A only if it fulfills the following requirements. The first is that the ship is seaworthy. How can we consider that a ship is seaworthy? A ship will be seaworthy once survey is undertaken and it complies with all the technical mechanical requirements, that it has the appropriate manning at place, it has the competency to sail from point A to point B as far as the respective voyage is concerned. If it is of a particular tonnage, it must be capable as far as the tonnage is concerned. If the builder has given the certificate through which it can be established that the modern requirements with respect to machinery, with respect to hull, with respect to boiler and with respect to keel and other parts of the ship has been satisfied with, then in such a scenario we can say that a ship is considered to be seaworthy. Internationally, we see that there are certain codes such as ISM and ISPS code which talks about the seaworthiness of the ship, especially the ISM codes which look after the structure of the ship and identify that what type of ship can be considered to be a seaworthy ship. In general, a ship may be an oil tanker, a ship may be a cargo carrying, different types of cargo carrying ship, a ship may be carrying hazardous or obnoxious substances. So, different requirements will come into being as far as seaworthiness of the ship is concerned. But here when we talk about pilgrim ship or special trade passenger ship or passenger ship in general, the requirements will be specific to the pilgrimage, or pilgrimage ship. here with respect to special trade passenger, the requirement will be with respect to special trade passenger ship. So, the certificate of seaworthiness has to be obtained, and this, in order to obtain it, the surveyor or the certificate giver will ensure that the ship is seaworthy, that is, it can sail. It should also ensure that if the ship is old, whether the ship can sail if it is 20 years old, whether a ship can sail if it is 40 years old, whether a ship can sail if it is 50 years old. What are the requirements as far as allowing a ship to sail from a concerned port is concerned. Further, we see that the ship is properly equipped, fitted and ventilated. When we say equipped, we are largely talking about the equipments that must be available, which are largely the permanent fixtures of the ship, which may also be including certain temporary fixtures such as the small boat, whether attached to a big ship, or other safety equipments that are necessary, or you can say mandatory, as far as life at sea is concerned. So, the surveyor would certainly, before giving the certificate, would take into account that the ship is properly equipped, fitted and ventilated. The number of special trade passengers the ship is certified to carry, and if it is allowed to carry only 100 passengers or 50 passengers, or whatever is the number, the certificate will consider or include within its details that the maximum number of persons that it can carry is the certain specified number, and such other particulars as may be prescribed. So, apart from these necessary requirements pertaining to seaworthiness, equipments and fittings and ventilation and number of passengers that can travel through particular ship, if there is any other requirement that is required, that is necessary to be mentioned in the certificate, will be mentioned in the certificate. And therefore, after this particular requirement mentioned, we can say that under clause 3, certificate A shall remain in force for a period of 1 year from the date of issue, or for such shorter period as may be specified therein. Further, we see under section 242 contents of certificate B. The second of the certificates, hereinafter called certificate B, shall be in the prescribed form and shall state the voyage which the ship is to make and the intermediate ports at which she is to touch. So, in the previous class we were discussing that the navigator plans the voyage. So, when such planning has already been completed, it will be mentioned in certificate B and it will be approved by the appropriate authority. So, once this approval comes into being, that approval comes into being mentioned in the certificate B. So, certificate A is specifically talks about the ship, and certificate B specifically talks about the voyage of the ship and the details of its mooring as it reaches to the port finally or its destination, or unmooring of the ship. It also can contain the ports at which it will take halt. So, the complete detail of the voyage, the planning of the ship will be mentioned in certificate B. That she has the proper complement of officers and seamen, that is, requirements pertaining to manning of the ship are also mentioned in the certificate B. The number of engineers that should be present at ship, the level of mate, first mate or second mate or navigational watchkeeping officer, the present will be mentioned in certificate B, and if both the requirements are complied with, then we can say that the ship can now move ahead with its voyage. We see that under clause C of section 242, it says that the master holds a certificate of survey and certificate A, or a passenger ship safety certificate accompanied by an exemption certificate if the concerned ship is exempted from the requirements of certificate A, a special trade passenger ship safety certificate and a special trade passenger ship space certificate, or a nuclear passenger ship safety certificate in the case where the ship is a nuclear ship. Then clause D says that she has on board such number of medical officers licensed in the prescribed manner and such number of attendants, if any, as may be prescribed. Clause E says that food, fuel and pure water over and above what is necessary for the crew and the other things, if any, prescribed for special trade passenger ships or pilgrim ships have been placed on board of the quality prescribed, properly packed and sufficient to supply the special trade passengers. Now, properly packed of packing of food and water is required, as the sea weather can be rough, especially for the perishable goods. Food forms one of the essential part. Now, if proper packaging is not done, or if proper arrangement is not made as far as fooding and lodging and water requirements of the crew and the passengers on the ship are concerned, then it can be devoid, or it can be refused to be granted the certificate B. So, certificate B will take care of all these things, that is properly packed and sufficient to supply this special trade passenger or pilgrims on board during the voyage which the ship is to make, including such a detention in quarantine as may be probable according to the prescribed scale. Clause F says that in case of a special trade passenger ship, if the ship is to make a voyage in season of foul weather, so if there is bad weather and the special trade passenger wants to make a voyage, then specified as such in the rules made under section 262, and to carry upper deck passengers, and that she is furnished with substantial bulwarks and a double awning or with other sufficient protection against the weather. In the case of a special trade passenger ship, the number of cabin and a special trade passengers embarked at the port of embarkation, such other particulars, if any, as may be prescribed for special trade passenger ships or pilgrim ships as the case may be. Now, section 243 talks about officers entitled to grant certificate once the requirements are complied with as far as certificate A and certificate B is concerned. Who are these officers that can grant this certificate? The person by whom certificate A and certificate B are to be granted shall be the officer appointed under section 238, who is hereinafter referred to as the certifying officer. So, in 238 we have already seen that the central government, for this particular purpose, that is issuing certificate A and B, central government will appoint a appropriate authorizing certificate officer. So, here we will call him certifying officer. Section 244 talks about survey of ship. After receiving the notice required by section 238, the certifying officer. So, under 238 we see that notice has to be given 24 hours before the survey is to be made, or before the departure at least it should be made, that is 1 day before. So, the certifying officer may, if he thinks fit, cause the ship to be surveyed at the expense of the master or owner by a surveyor, who shall report to him whether the ship is in his opinion seaworthy and properly equipped, fitted and ventilated for the service on which she is to be employed in, provided that he shall not cause a ship holding a valid certificate referred to in subclause 1 or subclause 2 or subclause 3 of clause C of section 242 to be surveyed, unless by reason of the ship having met with damage or having undergone alterations or on any other reasonable grounds, he considers it likely that she may be found unseaworthy or not properly equipped, fitted or ventilated for the service on which she is to be employed. So, the exceptional scenario in which the certifying officer can exempt the ship from the grant of certificate, we see that there must be an exemption certificate, and as we look at section 244, the proviso says that he shall not cause a ship holding a valid certificate referred to in subclause 1 and 2 of section 242 to be surveyed, unless by reason of the ship having met with the damage or undergone alterations. So, if there is any alteration that has been taken place, full detail of the alteration must be submitted to the surveyor, or if any damage has happened, then again the surveyor can reissue the survey certificate after resatisfying himself as far as the issue of certificate is concerned, in case of any doubt with respect to the seaworthiness of the ship. Then section 245 talks about discretion as to grant of certificate B. The certifying officer shall not grant a certificate B if he has a reason to believe that the weather conditions are likely to be adverse. Sorry, here we can say that the weather conditions are likely to be adverse, or that the ship has on board any cargo likely from its quality, quantity or mode of stowage to prejudice the health or safety of the special treat passenger or pilgrims. Further, section 246 says copy of certificate A to be exhibited. So, in the last class also we talked about, when we talk about general ship, passenger ships carrying passengers, and as far as documentary requirements are concerned, the certificate of seaworthiness has to be affixed on the conspicuous area of the ship. So, similarly here also for pilgrim ship or for special trade passenger ship which are unberthed passengers as such, the master or the owner shall post up in a conspicuous part of the ship so as to be visible to the persons on board thereof a copy of certificate A granted under this part in respect of the ship, and shall keep that copy so posted up as long as it is in force. Section 247 talks about special trade passenger or pilgrims to be supplied with prescribed provisions, and it says the master of a special trade passenger ship or any contractor employed by him for the purpose shall not without reasonable excuse the burden of proving which shall lie upon him omit to supply to any special trade passenger the prescribed allowance of food, fuel and water. And the master of a pilgrim ship or any contractor employed by him for the purpose shall not without reasonable excuse the burden of proving which shall lie upon him omit to supply to any pilgrim the prescribed allowances of food and of water as required by the provisions of this part. So, basic necessities have been taken care of as far as section 247 is concerned when we talk about unberthed ship, or as we may say special trade passenger ship or a pilgrim ship. Clause 2, it says, where under the terms of the ticket issued to a special trade passenger is not entitled to the supply of food by the master or owner or agent of the ship, subsection 1 shall in the case of such passenger have effect as if the reference to food in that subsection were omitted. Now, section 248 says number of passengers on board not to exceed that allowed by or under this part. Firstly, it says that a special trade passenger ship or pilgrim ship shall not carry a number of special trade passengers or pilgrims which is greater than the number allowed for the ship by or under this part. Any officer authorized in this behalf by the central government may cause all special trade passengers or pilgrims over and above the number allowed by or under this part to disembark, and may forward them to any port at which they may have contracted to land, and recover the cost of so forwarding them from the master, owner or agent of the ship, as if the cost were a fine imposed under this part, and a certificate under the hand of that officer shall be conclusive proof of the amount of the cost aforesaid. Section 249 says special trade passenger or pilgrim not to be landed at a place other than that at which he has contracted to land. No master, owner or agent of a special trade passenger ship or pilgrim ship shall land any special trade passenger or pilgrim at any port or place other than the port or place at which the special trade passenger or pilgrim may have contracted to land. So, basically the plan that already or that has been identified previously by the navigator, that particular plan cannot be deviated with. If a particular voyage has been identified, if a particular port where the ship will stop intermittently has been identified, that particular route should not be deviated, only in exceptional circumstances it should be exercised. So, it further says that unless with his previous consent or unless the landing is made necessary by perils of the sea or other unavoidable accidents. So, only in exceptional scenarios where there is distress or force majeure in place, only such scenarios we can say that voyage be allowed to be excused from the planned route. Further, section 250 says, talks about forwarding of passengers by Indian consular officers. If any special trade passenger from a ship which is on a voyage from any port or place in India finds himself without any neglect or default of his own at any port or place outside India other than the port or place for which the ship was originally bound or at which he has contracted that he should land, the Indian consular officer at or near that port or place may forward the passenger to his intended destination unless the master, owner or agent of the ship within 48 hours of the arrival of the passenger gives to that officer a written undertaking to forward the passenger within 6 weeks thereafter to his original destination and forwards him accordingly within that period. So, that comes up also as a benefit of sailing in an Indian ship. Clause 2 says that a passenger so forwarded by or by the authority of an Indian consular officer shall not be entitled to the return of his passage, money or to any compensation for loss of passage. Section 251 talks about recovery of expenses incurred in forwarding passengers. All expenses incurred under section 250 by an Indian consular officer in respect of the forwarding of a passenger to his destination, including the cost of maintaining the passenger until forwarded to his destination, shall be a debt due to the central government. So, all of that expenses that was incurred by the Indian consul officer will be considered due in favor of the central government. So, it will be a debt due to the central government jointly and severally from the owner, charterer, agent and master of the ship on board which the passenger had embarked. So, the master or the ship owner will be held responsible for all that expenses that had been incurred by the Indian consular officer. Now, friends, apart from the discussions that we have as far as safety and security of the special trade passenger or special trade passenger ship is concerned, or the pilgrimage ship is concerned, or in the taking into account the last lecture the passengers safety and security is concerned, seaworthiness of the ship is concerned. Let us now discuss carriage of goods by sea, that when goods are carried through sea, what are the shipping laws that are applicable in India, what are the legal requirements as far as carriage of goods are concerned. So, we see that shipping has always been the oldest mode of transport in India as far as commercial transaction is concerned. It has also highly benefited the international trade. In order to flourish the international trade, there must be an involvement in the transaction of goods by sea between a buyer in one country and seller in another country, and that is how the trade will be considered to be international, of international character. The carrier plays a very significant and important role in this contract, and it is necessary to understand its involvement in the marine contract in regards to his obligations and immunities. Further, delivery of goods is one of the most significant obligation of carriers and a core issue about carriages of goods by sea. The carrier's obligations under the contract are to be discharged after the delivery of goods is complete. Therefore, the Hague rules, the Hague-Visby rules, the Hamburg rules, Rotterdam rules and the Indian Carriages of Goods by Sea Act 1925 governs the carrier's rights and liability in carriages of goods products by sea. Now, we see that India had passed its Carriage of Goods by Sea Act in the year 1925. After it adopted the Brussels Convention on Maritime Law, which contained uniform rules of bill of lading derived from the Hague rules of 1924. Now, we require uniform rules for the very basic reason that since goods travel from one country to another country, if there are no uniform rules, it will be difficult for the carrier also, and it will create anomaly and absurdity as far as application of rules with respect to rights and liabilities of carrier are concerned, or with respect to rights and liabilities of the purchaser and the seller are concerned. Once the rules are uniform, it becomes possible and easy for the carrier as well as the seller and the buyer as far as this transaction is concerned, which is taking place between two nations by private players. So, to facilitate the uniformity of transaction, uniform rules of international nature are adopted by the states, and therefore, we see that the Carriages of Goods by Sea Act was adopted in the year 1925, and it was done as a result of Brussels Convention on Maritime Law, which contained uniform rules of bill of lading, derived from the Hague Rules of 1924. Now, as it talks about rules of bill of lading, what is a bill of lading? A bill of lading is a document that contains the details of the goods that are to be transported from one part of the world to another part of the world. It is also considered to be or equivalent to the ownership of the goods. They are generally handed over to the purchaser, and carrier takes it on behalf of the seller and hands it over to the buyer, and they are generally handed over to the buyer once the payment has been made by the buyer to the seller. Not necessarily, it will also depend upon the type of contract, type of dealing, type of transaction that is taking place between the seller and the buyer. So, therefore, we see that Carriages of Goods by Sea Act 1925 governs the shipping of goods from one port in India to other port in India or outside India as well. Thus, this act governs the shipment of goods carried by national coastal vessel within the country and goods carried by foreign going vessel. So, the national coastal vessels are also covered under the Carriage of Goods Act, as well as the vessels that go abroad. Further, a contract for carriages of goods by sea comes into effect only by issuing a bill of lading under Bill of Lading Act 1856. Generally, when goods are shipped from one port to another, there arises a risk of damage to the goods, and in this case it is difficult to ascertain the extent of liability of a person in case of the damage. Thus, to put an end to this particular problem, the conduct of the parties is governed by the Carriage of Goods by Sea Act 1925. This act provides for the responsibilities and liabilities which induces the carrier to exercise diligence while shipping and to ensure that the ship is securely manned, equipped and supplied with the essentials which are required for the safe reception of the goods. For example, friends, if the goods that are supplied are of perishable nature, then that particular good to be properly, safely transported from one country to another country or one coast to another coast in the same country, it would require a certain temperature. So, certain equipments will be required, storage equipments will be required. If the same temperature is not maintained, or if the equipment is not present, or if it is working but it is not properly working, it is in defect working, in such situations, then the carrier can be held responsible or liable for not complying or for omitting the duty that it was bound to do. And all of these duties, relevant duties, are being dealt under Carriage of Goods by Sea Act 1925. Non-observance of these responsibilities by the carrier gives rise to liability, and the carrier would be liable for compensation. Friends, the legislations which govern the multimodal transportation of goods by sea in India will include or are the Indian Bills of Lading Act 1856. It is a very small act, talks about bill of lading, what will it be composed of, and what are the certain rules available as far as bill of lading is concerned. Then you have Carriage of Goods by Sea Act 1925, and then you have Merchant Shipping Act 1958, which largely, let us say, deals with seaworthiness of the ship, obtaining of certificate, and as we had already just discussed now. So, when goods are carried, whether with respect to goods, whether manning and equipment etc. is in place, certificates are in place, whether survey has happened or not, certificates have been issued or not, all of these aspects are covered under Merchant Shipping Act of 1958, and we had just discussed certain special provisions with respect to passenger, with respect to special trade passenger, or with respect to pilgrim. But at the same time, with respect to goods also, Merchant Shipping Act provides for necessary regulations to be undertaken, rules to be undertaken in order to ensure that the ship is seaworthy as far as carriage of goods are concerned, in order to ensure that the proper manning is in place as far as transportation of goods is concerned. Then we have Marine Insurance Act of 1963, as it provides for insurance of ship, as provides for insurance of goods. If any mishap happens, and due to which under the covered regime of losses, protected regime of losses as far as insurance is concerned, Marine Insurance Act of 1963 protects the owner of the good, protects the owner of the ships or master in scenarios where the coverage is available as far as goods or ship are concerned. And when we talk about goods, if there is no fault or and due to distress or force majeure or under any covered scenario, if there is damage caused to ship, Insurance Act will come into being, where the insurance is mandatory and insurance will protect the interests of the owner of the goods. Combinedly, all these 4 acts, that is the Bill of Lading Act, Carriage of Goods by Sea Act and Merchant Shipping Act and Insurance Act, can be considered to be a multimodal transportation of goods by sea, as multiple acts and multiple areas are covered under these different acts, and they are also interrelated to each other. So, the act defines the carrier and says, when goods are shipped on a chartered vessel for a consignee, they face specific difficulties in the incident if the cargo is lost or damaged. Therefore, the carrier has to be identified as to who the cargo claims can be conducted and establish a defined term in the contract of carriages. So, the contract itself will identify that who is the carrier and who is the one who is taking the responsibility as far as the carriage of goods are concerned. So, the contract will primarily identify and define that who is designated to be a carrier. The bill of lading is to be signed by the ship's master as an agent of the ship owner and can be issued in the name of the charter, subcharter, ship owner or the agent, as it is vital for the claimant to make a correct decision as to which person he or she has to sue in case any default or liability accrues out of the act. Then the carriage of goods by sea has various conventions that define the carrier in certain ways, as it is necessary to know as to who is a carrier and what purposes does it serve in the rules. Although the carrier's definition has not much of difference in the conventions, the carriage of goods by sea has various conventions that define the carrier in certain ways, as it is necessary to know as to who is a carrier and what purposes does it serve in the rules. Although the carrier's definition has not of much of a difference in the conventions, the Hague-Wisby rules defines carrier as the person who convinces the owner or the charterer or who enters into contract with a shipper. So, therefore, a carrier is a person who is in direct dealing and convincing the owner or the charterer or who enters into contract with a shipper to act as a carrier in order to transport goods from one particular port to another port, that is the seller and the purchaser also. The carrier has also been identified as the person that has the name in the contract of carriages of goods by sea that concludes the shipper. This particular convention has also defined an actual carrier as a person to whom the enactment of the carriage of goods or part of the carriages has been delegated by the carrier and made any other person to whom such performance has been entrusted. In India, identifying a carrier when goods are carried on a chartered vessel may seem problematic when the ship owner or a person who is not a party to the charter party holds the bill of lading. So, the ship owner and the charterer were to have a contract between them in order to form a charter party, carrier and cargo interest to form a bill of lading. So, basically when we say that there is a shipper, there is an owner, there is a charterer, we must in simple scenario understand that a ship owner may not necessarily be using its own ship to transport goods from one place to another place. The ship may be on lease under demise charter, a ship may be on rent, let us say there is a contract of time charter for a particular time period for a particular voyage also. So, the one who charters the ship is the one who is taking the ship from one place to another place. So, it is the charterer who is actually having the possession of the ship that belongs to the ship owner, and for this a charter party agreement also is entered into. The carrier can be clearly identified by a contract as being the ship owner or the charterer. However, in some situations the carrier can either be the charterer, ship owner or sub charterer. It is all related to the circumstances and commercial position of the vessel. The Indian Carriages of Goods by Seas Act 1925 defines carrier as the owner or the charterer who enters into a contract of carriages with a shipper. As India has embodied the Hague Rules, that is relatively same as the English Carriages of Sea Act, hence there is not much of a difference in defining who the carrier is under the Indian law, although the English law has ratified the Hamburg Rule, which defines the difference between the carrier and actual carrier. Now, when we talk about the provisions of COXA, that is Carriage of Goods by Sea Act 1925, Article 1 defines certain important terminologies. First one will be contract of carriage, applies only to contracts of carriage covered by a bill of lading or any similar document of title, insofar as such document relates to the carriage of goods by sea, including any bill of lading or any similar document as aforesaid issued under or pursuant to a charter party from the moment at which such bill of lading or similar document of title regulates the relations between a carrier and a holder of the same. Goods has been defined, and it says includes any property including live animals as well as containers, pallets or similar articles of transport or packaging supplied by the consignor, irrespective of whether such property is to be or is carried on or under the deck. So, a goods may be kept on deck, it may be kept under the deck as well, where the containers are stored. A ship means any vessels used for the carriage of goods by sea. Further, carriage of goods means covers the period from the time when the goods are loaded on to the time when they are discharged from the goods. So, carriage of goods would mean once they are loaded until the point of time they are unloaded, the complete period during which the goods are on the ship would mean carriage of goods. Further, under Article 3 it has been identified that what are the responsibilities and liabilities of a carrier, which may be the ship owner, which may be a subcharterer, or which may be a charterer as well. It says under clause 1, the carrier shall be bound before and at the beginning of the voyage to exercise due diligence to make the ship seaworthy, and how to make a ship seaworthy has already been discussed in the previous lecture. That manning of the ship is there, the equipments are in place, the requirements of the ship with respect to updated machinery or machinery in general is present. It has not crossed the number of years. So, whatever requirements are placed under the rules and regulations under Merchant Shipping Act through its rules and regulations of 1960, those requirements must be in place, and once a ship is qualified to be seaworthy, then we can say that it can continue on its voyage. So, the carrier is having this responsibility before it loads the good, before it starts its voyage, to ensure that the ship is seaworthy, properly man, equip and supply the ship. If the ship is not seaworthy, proper manning and equipment is not in place, then in such a scenario, for any loss that may accrue as far as the goods are concerned, we can say that the ship we can say that the fault is that of the carrier. Make the holds, refrigerating and cool chambers and all other parts of the ship in which goods are carried fit and safe for their reception, carriage and preservation. Subject to the provisions of Article 4, the carrier shall properly and carefully load, handle, stow, carry, keep care for and discharge the goods carried. After receiving the goods into his charge, the carrier or the master or agent of the carrier shall on demand of the shipper issue to the shipper a bill of lading showing among other things the leading marks necessary for identification of the goods, as the same are furnished in the writing by the shipper before the loading of such goods starts, provided such marks are stamped or otherwise shown clearly upon the goods if uncovered, or on the cases or coverings in which the such goods are contained in such a manner as should ordinarily remain legible until the end of the voyage. Either the number of packages or pieces, or the quantity or weight as the case may be, as furnished in writing by the shipper. The apparent order and condition of the goods, provided that no carrier master or agent of the carrier shall be bound to state or show in the bill of lading any marks, number, quantity or weight which he has reasonable ground for suspecting not accurately to represent the goods actually received, or which he has had no reasonable means of checking. Such a bill of lading shall be prima facie evidence of the receipt by the carrier of the goods as therein described in accordance with para 3a b c. However, proof to the contrary shall not be admissible when the bill of lading has been transferred to a third party acting in good faith. The shipper shall be deemed to have guaranteed to the courier the accuracy at the time of shipment of the marks, number, quantity and weight as furnished by him, and the shipper shall indemnify the courier against all loss, damages and expenses arising or resulting from inaccuracies in such particulars. The right of the courier to such indemnity shall in no way limit his responsibility and liability under the contract of carriage to any person other than the shipper. So, there are certain rights and liabilities which a carrier contains as far as such transportation under the act is concerned. After the goods are loaded, the bill of lading to be issued by the carrier, master or agent of the carrier to the shipper shall, if the shipper so demands, be a shipped bill of lading, provided that if the shipper shall have previously taken up any document of title to such goods, he shall surrender the same as against the issue of shipped bill of lading. Further, any clause, covenant or agreement in a contract of carriage relieving the carrier or the ship from liability for loss or damage to or in connection with the goods arising from negligence, fault or failure in the duties and obligations provided in this article, or lessening such liability otherwise than as provided in these rules, shall be null and void of no effect. A benefit of insurance or similar clause shall be deemed to be a clause relieving the carrier from liability. Then we have article 4 that talks about rights and immunities as far as the carrier is concerned, and we have several other rights and obligations that come either in the interest of carrier or liabilities that goes against the carrier, such as article 5, which talks about surrender of rights and immunities and increase of responsibilities and liabilities. Then article 6 talks about special conditions. Article 7 of the act talks about limitations on the application of the rules, and article 8 talks about limitation of liability. Here article 7 says that nothing herein contained shall prevent a carrier or a shipper from entering into any agreement, stipulation, condition, reservation or exemption as to the responsibility and liability of the carrier or the ship for the loss or damage to or in connection with the custody and care and handling of goods prior to the loading on and subsequent to the discharge from the ship on which the goods are carried by sea. And article 8 says that the provisions of these rules shall not affect the rights and obligations of the carrier under any statute for the time being in force relating to the limitation of liability of owners of sea-going vessels. So, friends, this will be all about the rights and liabilities of carriers as far as Carriage of Goods by Sea Act 1925 is concerned, and what do we understand by the important terms such as the carrier as far as the word good is concerned, carriage of goods by sea is concerned. So, the application of seaworthiness and manning and equipping mentioned in the Merchant Shipping Act also comes into play as far as the Act's liabilities and rights are concerned. With this, I will conclude this particular lecture on safety and navigation as far as shipping laws in India is concerned. Thank you for your patient listening. Namaskar.